So they built a detention center in the Everglades in days. Not years, but mere days. And they called it Alligator Alcatraz. A federal judge just froze the expansion for 2 weeks. So if you care about this stuff and real deportations instead of all those performative pressers, stick with me. Because by the end of this video, you'll know the 4-part legal test that will decide this pause and the one document that will most likely tip the whole case. So here is the lay of the land. It is a remote training airfield in Florida, Dade Collier, out where heat mirages look like rivers. And it was converted, basically overnight, into a high-capacity civil immigration detention site. Now, this distinction matters because it's not a prison, it's a holding facility tied to removal proceedings. Civil detainees aren't being punished for violating any law, rather they're simply being held while the government figures out what to do with them. But the core here is simple. You can't enforce immigration law if you don't have the capacity. And the adjacent problem is you can't have the capacity if you haven't built the infrastructure. So Florida has enacted an emergency state authority to move quickly because, of course, this problem isn't theoretical, especially for Florida. When law enforcement ramps up and there's no place to stage people for those hearings and transport, you either have to stop enforcement or you triage in a more chaos environment. So the state's position is about straightforward as it all gets. We build it, we run it, and we lease the space to the feds if the feds want to stage people from the operation. Now, from a conservative rule of law perspective, that isn't outrageous, it's competent. States, of course, are allowed to help the feds enforce federal law if they want. But at least according to Florida, Alligator Alcatraz isn't making up rules, rather it's merely keeping order in an already existing system. So why the 2-week pause? Because the plaintiffs, comprising environmental groups, tribal nations, and a civil liberties group, say the facility is really a federal project in disguise. Now, if it is a federal project, that can come along with federal environmental laws. And those laws could require our view that looks at a wide swath of the project at both direct and sometimes indirect effects. It also requires consultation and checks that go a lot deeper and are a lot more thorough than a state agency's procedure can be. But let's get rid of some of this legal jargon and decode the test that's in play. In order for the plaintiffs here to win and maintain this pause, they'll have to show 4 things to get a longer pause, an injunction. They have to show that they're likely to win, that they're going to suffer harm that money can't fix, the balance of equities favors them, and public interest weighs in their favor. Environmental cases often turn on that second factor. The real fight here is over that federal handle. If Florida truly built this with state money, under state control, with federal agencies just renting the beds later, then the state can reasonably argue that this isn't a major federal action. But if cabinet secretaries and their staff were hitting reply all, approving the site and design, and federal money was in the mix, then those federal protections land with a more hefty punch. But key, environmental law is not a veto pen. And of course, you have to remember the geography. This was a pre-existing structure. It wasn't just native swampland. This was a runway before anyone rolled out a cot, and that obviously lessens any environmental impact. If you're adding modular housing and secure corridors on an already disturbed footprint, that is obviously a different harm than bulldozing fresh mangroves. And courts will notice these kinds of distinctions. The other flank is the conditions and due process. Civil detention, of course, requires notice, access to counsel, and a meaningful path to a bond hearing or custodial review that works, but only within an immigration context in which the rules are significantly restrained from normal court processes. Now, in all these considerations, when I'm bringing these things out, I don't want to sound soft on law enforcement or immigration enforcement, much to the contrary. I favor immigration enforcement. I'm just insisting that we make every possible step to make those enforcements stick on any possible appeal. Otherwise, we just jam the people up in the system and we pretend we have an effective operation, but ultimately it might blow up in everyone's face. The government, of course, can be both firm and lawful. And if you want deportations that last the test of time, including appeals, you want to build processes that last with them. A federal judge can tell a state not to build a state facility, and it would be lawful for that judge to do so if it has those federal hooks. The law allows for such kinds of pause if the pending state action conflicts with federal law, specifically federal mandates or obligations. Remedies here could take different forms. The court could direct the production of brief environmental assessment or a more substantive impact statement, or specific types of monitoring while work continues. If you look at it from the enforcement side, Alligator Alcatraz seems to be a long overdue adult decision. More capacity, less chaos, and faster removals. That is, fewer illegal alligators roaming about, if nothing else. Now, what about that most important document? Perhaps a contender for the most important document is an intergovernmental agreement that probably exists. This is a paper that would convert the headline into the formal legal position by the parties. A real written agreement between Florida and the federal government that specifies exactly who did what and when and in what capacity. So if this is actually just a plain lease with no federal fingerprints on site selection, design specs, or operational control, that would point to state project, federal tenant, which, as I say, would weaken, if not eliminate, any federal claim of action here relating to environmental concerns. But if it looks more like a memorandum of understanding where the agencies actually coordinate in deciding the location, layout, intake priorities, or staffing considerations, then the plaintiffs have a better argument for arguing the federal environmental law here applies because of the more increased involvement by the feds. Now, I don't mean to suggest there's any kind of improper conspiracy here. Federal governments and state governments work together all the time on all kinds of projects. Now, Florida was absolutely right to want to move fast. I am a firm believer in enforcing our immigration law. But the best way to beat lawfare is not by skipping the law. It's by following it so cleanly, the only thing left for your opponents to do is fight with their own rhetoric. Do you want deportations that actually happen and actually stick? Then what you want is facilities designed for speed, accountability, and an appeal-proof process. Litigants in civil liberties have a role in this as well, but the process should be aimed at fidelity, not sabotage. If there are issues with access to counsel that need addressing, then I, as a lawyer, of course, am very interested in making sure those issues are corrected. And the court can do so with a scalpel, not a sledgehammer. And none of this undermines deportations. It ultimately protects them. So I end where I began. Alligator Alcatraz was built at speed because the system needed it yesterday. Let me know in the comments if you think I've erred in any way. If you made it to this part of the video, type due process in the comments so I'll know you're one of the people who actually prefer solutions to problems. And yes, of course, do all the stuff you do on YouTube, like sharing, and subscribing, because sometimes the algorithm is not a fan of the rule of law unless you make it be. So until next time, I've been on civil law, and make sure to keep it uncivil out there. Peace.